For purposes of this story, remember we consolidated the three applications. So the first applicant is Ferdinand Waititu in E006 of 2025. The second applicant is Charles Tegebuthia in E008 of 2025. And the third applicant is Kiambu Wahinya in E008. As the Republic. The applicants herein were convicted of various offences and were sentenced to serve 12 years in prison or a fine of 53.5 million, 11 years imprisonment or a fine of 296,548 and 110, and 7 years or a fine of 21 million respectively. 5 applications dated 14th of February 2025, 17th of February 2025, and 18th of February 2025, the applicants have moved this court with applications for bail to be admitted to bail pending hearing and determination of their appeals. They all state that they are aggrieved by the convictions and sentences imposed on them by the trial court, and they have filed their respective appeals challenging both the conviction and the sentences. The applications are supported by the grounds set out on the bodies of the respective applications and on the supporting affidavits owned by the applicants. The application is opposed. On record, our grounds of opposition dated the 20th of May 2015, stating the following grounds. I won't state, because you have the grounds. When the applications came up for hearing on 24th of February 2025, they were consolidated and counsel argued the applications together. On the part of the applicants, it was submitted that the appeals raises good grounds and they have chances of success, as the grounds raised are weighty in that they have attached the evidence and the determination of the trial court on both the fact and the law. They stated that their clients are incarcerated, and from the way the courts operate, it will take some time before the appeals are heard and determined. Reference was made to various decisions, which we'll look at when we see the ruling. In the submissions, chances of success and whether there exist exceptional circumstances to warrant granting of bail. The applicants in their submissions are all matters of facts and not points of law. That no point of law has been pointed by the applicant to convince the court there is an arguable point of law. The review of the analysis of the evidence and the conclusions to be drawn on facts which were raised by the applicants should be matters that can only be determined during the hearing of the substantive appeal and not at this point. Otherwise, as at now, there was no point of law that was advanced by the applicants in their submissions, and that the applicants are sole breadwinners and their families have been rendered destitute with the continued incarceration of the appellants. I have referred to a number of authorities, circumstances where medical facilities are available for prisoners and where the prison is equipped to take care of the ill health of the applicants, and where, if need arises, the prison's personnel may seek referral to other facilities outside the prison, like it was appeal will be given a hearing date. We all know appeals are usually disposed of by way of written submissions. This court can confirm that hearing of the appeals in under 2 months from now, meaning that the appellants will not have sentences bearing in mind the respective sentences by each of the applicants. Having considered all the above, it is my finding that the applicants have not met the conditions for grant of bail pending appeal. The applications are hereby dismissed. The appeal shall be heard on priority basis, given that the applicants herein are in custody.